Hi there, everybody. This is Samantha Wolfe from the Law Offices of Samantha Wolfe. I am talking to you from our conference room at our office here. We're located at 20 East 6th Street in Suite 206 in Waynesboro, PA. And you can reach us at 717-655-2676. And this morning, I just wanted to take a few minutes and talk to you about powers of attorneys. I know I have done a segment or a virtual seminar where I talked about all of them at once, but I thought it might be helpful for me to break it down into each separate document and to thoroughly go through each document. My hope is that maybe this will provide some understanding regarding financial powers of attorneys. And again, after you've watched this or any other of our videos, please know that we do offer free initial consultations, and we're happy to review your documents at that time and make any recommendations regarding updates that we might think would be helpful for you in the future, or just to discuss the general provisions that you might have. But for those of you at home who just want to be able to walk through your documents and see what do you have, what should you change, I wanted to provide an instructional video. What I am going to do is I have a PowerPoint that has examples of the language and has things kind of written out for you. So I wanted to be able to share my screen so that everybody can see that. So I'm going to share my screen right now. So just hang on just 1 minute and let me do that. Okay, so this is a picture of the front of our office. Like I said, we're located at 20 East 6th Street in Suite 206 in Waynesboro, and you can reach us at 717-655-2676. Now, today we're going to focus on the powers of attorneys. We call them our Hot Five. So these are part of the 5 documents that we recommend every individual to have in place. So if we're meeting with a husband and wife, we actually think each individual, each spouse should have these documents, one of each. So we have 4 power of attorney documents, and then we have the last will and testament. So the 4 power of attorney documents are the financial power of attorney, the healthcare power of attorney, the living will, and a mental health power of attorney. Of those 4 power of attorney documents, what it really is just generally a power of attorney is a written legal document where one person, the principal, authorizes another, that's called the agent, to act on his or her behalf. So for example, if I were to execute a power of attorney, I would be the principal and the individual who I appoint would be the agent. And this is really important because if you don't have a written power of attorney document naming who you would want to handle certain events, certain assets, certain medical decisions, then it could be possible that those in your life would have to petition the court to be able to be appointed as the guardianship. So a power of attorney is really where you're kind of taking the reins and saying, this is who you would want to appoint. It's really an empowering document. It's giving you the ability to make these decisions rather than leaving it up to a court of law. So these are our 4 power of attorneys. Like I said, we have a financial power of attorney, a healthcare power of attorney, a living will, and a mental health power of attorney. And just as a reference, I'm going to do a video on each of the other power of attorneys, but today I wanted to focus on what I consider the MVP of the powers of attorneys, and that's our financial power of attorney. So again, all 4 of the power of attorneys are needed and are going to work in different situations, but the most important one is probably the financial power of attorney. I'm going to explain why that document is so important, but just think of that as the MVP of the power of attorney documents that we have. So the first question that I would tell you to determine or to answer would be whether or not you have a durable power of attorney or a springing power of attorney. So if you have documents that you've already executed, if you've already executed a financial power of attorney, I would encourage you to pause the video and go grab that document, because I'm actually going to be going through it with you so that you can determine what does your document have in it and if you need to make any changes. So if you have one, I would recommend that you go get one to follow along. If not, if you haven't had a document, what I'm going to do is I'm going to go over different provisions that I think are really important for every person to have in there. And so you're welcome to take any notes regarding that. And I also welcome any questions. You can put any questions in the comments below, and I'd be happy to either answer you by writing back, or I can also do a video explanation if that's needed. So the first thing that I wanted to talk about was there are two major types of financial power of attorneys. There's a durable power of attorney and there's a springing power of attorney. So a durable power of attorney means that it is effective when you sign it and when your agent acknowledges it. So remember, you're the principal. So when the principal signs it, and we usually sign it in the presence of a notary with two witnesses. And then when your agent, whomever you're appointing, signs it in front of a notary, then it would be considered effective at that time. So it doesn't require a physician to say you're incapacitated in order for the financial power of attorney to be effective. Now, how do you know which one you have? So what I have here on screen is this is an example of what we'd call a springing power of attorney. And the reason why it's a springing power of attorney is because if you look here under the effective date, it says that it shall become effective and the agent shall be authorized to act while I'm disabled or incapacitated. So meaning that it's not effective right now, it springs into action if I would ever be incapacitated or disabled. And what does that mean? So there's a Pennsylvania default, but then there's also a document could say under which conditions does it become effective. And here what it's saying is that in the opinion of a physician who is not related to me and is lawfully qualified to practice medicine, is familiar with my condition, that would be who determines whether or not I would be disabled or incapacitated. So this is an example of a springing power of attorney. It's not effective right now. It would only be effective under these conditions if I'm disabled or incapacitated, and that would be determined according to the opinion of a physician. So this is an example of the language of a springing power of attorney. Now, as you're looking at your power of attorney, I would encourage you a lot. You can tell by the title. So at the top, does it say it's a durable power of attorney? Does it say it's a springing power of attorney? And then either if it's silent on the issue, if there is no heading labeling what type of power of attorney, or even if there is, but you find language talking about an effective date of when you're disabled or incapacitated, then it is a springing power of attorney. Okay, so again, this is an example of a springing power of attorney. This is an example of a durable power of attorney. So this is saying that the intent is to create a durable power of attorney under the laws of Pennsylvania, and that the agent is going to be able to act immediately and is not going to be affected by subsequent incapacity. Meaning that if I sign this document, again, I sign it in the presence of a notary and two witnesses, and then my agent acknowledges it, signs it saying they're willing to accept the position, then this power of attorney would be effective at that time. It wouldn't require me to be incapacitated or disabled. Further, the durable power of attorney is going to stay in place until either A, my death, or B, if I would revoke it at any point. Otherwise, this document is remaining in effect. So again, this was the example of a springing power of attorney, talking about disabled or being incapacitated, and this an example of a durable power of attorney. So I know the question everybody's thinking is, why is this important? So at our office, we recommend a durable power of attorney. So we're going to recommend this type of language be in your document. And there are a lot of reasons why we do this. The first is that if it is a springing power of attorney, again, it requires a medical professional to be consulted. So, if there's an emergency situation, it still is going to require a physician to say that somebody's incapacitated. And so we like it for ease of protecting our client. So, and a lot of times we're helping people plan for the second half of life. So people who are 50 and older, who are looking at preserving assets or maybe being admitted into a nursing home, and we're looking at what provides that individual with the most protection. So we always recommend a durable power of attorney. The thought being that if you trust somebody to act, then you would want them to have the most power under Pennsylvania law that they can have. Now, what I will tell you in our office, just as a practice tips, what we recommend is if we have mom and dad, a husband and wife come in and they've appointed each other, we have them sign each other's so that they could act immediately if they would need. But if they've appointed children as successor agents, a lot of times we don't have the children sign their acknowledgement page. We only have them sign if and when they would ever need to serve. And that way the children don't have the power prior to mom and dad wanting them to have the power. But if they would ever learn of a situation in which they would need to act as power of attorney, all they would have to do is sign it in the presence of a notary. So again, those are some ways that we make sure to protect the client, but we really do feel like if you're appointing a power of attorney and this is someone you trust, then you would want them to be able to act immediately and not wait upon some event. And there are a lot of long-term care planning reasons why, and I will explain that in some later slides, why that's so important and why monetarily that makes such a big difference. Okay, so as we're talking about the financial power of attorney, what sort of powers are in the document? So, a financial power of attorney is going to allow the open and closing of bank accounts and selling of real estate, the defense and litigation. So, if you have any court case or any matter involving the court system, it allows your agent to act on your behalf. It can allow your agent to make gifts, and it can allow your agent to create a trust. And how Pennsylvania works is that Pennsylvania has a statute that kind of outlines what general powers you can give your agent. And then there are certain powers that you have to specifically grant your agent the power to be able to do certain things. And there's specific language that has to be used. And so, what are those powers? And we call these our hot powers, meaning that you specifically have to have language in the document allowing your agent to be able to do these things. So, the first thing is unlimited gifting. The second thing is power to create irrevocable trusts. The third thing is digital assets and handling your digital assets. And then the last thing is beneficiary designations. So, again, if you want your agent to have any of these four powers, you specifically have to grant them the power to have these specific or to be able to do these specific tasks. And again, the statute actually says the specific language that you have to authorize your agent in order to be able to do that. So let me give you an example. What I did is I took a picture of a power of attorney. This is a common type of power of attorney form that we see in our office. So if we are going to do an initial consultation, we have the clients bring in their documents. And when I'm looking through the power of attorney, this is what I see most often, a list of what your agent can do. Okay. So as you see under number one, they would have the ability to engage in banking and financial transactions, dealing with stocks or bonds, engaging in real property transactions, borrowing money under a safe deposit box. So it lists all the powers there. Now, what I will tell you is when we go back to this slide and it lists the hot powers, so there's four powers that have to specifically be granted in order for your agent to be able to do those things. And then we flip over here to where the actual powers are. For example, if you look at number 8 and number 9, so the ability to engage in insurance transactions and the ability to engage in retirement plans transactions. What that means is that your agent has these general powers. But if you were to go somewhere like Edward Jones or a bank and you would want to update beneficiary designations on the account, because that's specifically not provided in here, the bank is not going to allow you to do that, or the financial institution is not going to allow you to do that. Furthermore, as you go down under number 14, you'll see that it allows your agent to create a trust for my benefit. So what that means is that if my agent would need to, the agent could create a trust and transfer assets into it. But under Pennsylvania law, because it just says to create a trust and it specifically doesn't allow an irrevocable trust, then my agent can only create a revocable. So there are two types of trust. There's a revocable and an irrevocable trust. And under number 14 here, this would only allow me to create a revocable trust and not an irrevocable trust. Why this is so important is, let me give an example in just my own family. So my mom and dad, let's say that my dad would go into a nursing home. So he would be actually living there. And let's say my mom is in the community and my dad needs skilled level care, meaning that he needs help with 2 out of the 5 daily activities of living. The daily activities of living are things like mobility, eating, toileting, those type of things. So if my dad would need assistance with 2 out of those 5 activities, then he may be eligible for skilled level care. Skilled level care is a type of care that Medicaid will cover. So if, for example, my dad gets into a nursing home and he wants to apply for Medicaid, and there are a couple of reasons he might do that. The first is that he may want to apply for Medicaid so that my mom doesn't have to use all of her assets to pay for his care, so it doesn't leave my mom financially compromised. So what my dad might want to do is he might want to be able to either set up a trust or to make transfers to my mom. Okay, so if my parents came in and they had the power of attorney that is like on our screen, what this would do is the attorney would be going through the document to determine whether or not my mom, as my dad's agent, if my dad did not have capacity, would have the ability to do these things. Okay, so to apply for Medicaid benefits, to create a trust, to make transfers. And that would even be between each other. So, for example, if mom and dad have their house and they want to transfer it to just my mom's name and take my dad's name off the house to protect it from a Medicaid recovery lien, this power of attorney would not allow my mom to be able to do that if my dad didn't have capacity. And the reason is because as you go down through these powers, it does not allow the agent to be able to make any gifts or any transfers. None of these powers. So when we're listing 1 through 22, nowhere in there does it allow the agent to make gifts. So even between mom and dad, if my parents are both on the deed and my mom wants to take my dad's name off of it to protect it against a Medicaid recovery lien, that would technically be a gift between my parents because my mom is not buying out my dad's share, his 50% of the house. So if my mom wanted to take my dad's name off and put it in just her name for nursing home planning protection, this power of attorney would not allow my mom to be able to do that. It wouldn't allow my mom to be able to set up a trust either and transfer assets in there if she wanted to protect assets. It would not allow my mom to be able to update beneficiary designations for my dad either. So, in order to allow my mom the maximum amount of power to be able to protect assets and be able to do what she would need for my dad, this language in here does have to be beefed up, if you will, to be able to allow my mom to be able to do that. And so let me give you an example of what that looks like. So for example, if we flip back here, under number 14, it allows my mom the ability to create a trust for my dad's benefit. But again, under Pennsylvania law, my mom would only be allowed to create a revocable trust. And if my mom is trying to protect assets from nursing home costs for my dad so that she's not financially compromised, she would not be allowed to do that under this power of attorney. So what our office does is we use language like this that says that my mom has the ability to create, fund, amend, modify, revoke, or terminate a revocable or irrevocable trust. So again, because this is considered a hot power, the Pennsylvania statute says that I specifically have to grant in the document the ability for my mom to be able to do that. And it has to specifically say an irrevocable trust in order for her to be able to do that. So if you have language in your power of attorney that looks like this about creating a trust, we actually need it to look more like this. Okay. The next one is the gifting language. So if we go back to our language here, nowhere in here are you going to say the ability, you're not going to see that the agent has the ability to make gifts. So what we want to do is we want to make sure, again, in the example of mom and dad, that even between each other, they're allowed to make transfers. And that's to protect each other, to make sure that either they're able to qualify for Medicaid or even so that my mom is just not financially compromised if my dad would need care. So what does that language look like? This is an example of that. So it would allow the agent, my mom, to be able to make unlimited gifts without regard to the federal estate tax annual exclusion limit. That's that $15,000. It used to be $10,000. So a lot of times when I meet with clients, they say, well, I can give the $10,000. Because of increases in inflation, it's now $15,000. But what this is saying is that you can do that without regard to that exclusion amount, meaning that you're not limited to the $15,000, and that you can do it to qualify for or to receive government benefits, including but not limited to medical assistance, Medicaid, Social Security income, and veterans benefits. Now, why this language is so important is because if we don't have this language talking about unlimited gifts, then my mom is only allowed to make a transfer of $15,000. So again, if we're talking about their house and protecting the house, if my mom's still living in there and wants to protect it from a Medicaid recovery lien, she would have to take my dad's name off of it. And in order to do that for Medicaid purposes, that would be considered a gift because she's not buying out my dad's interest. And their house, his share of the house is going to be worth more than $15,000. So in order for my mom to be able to do that, if my dad doesn't have capacity, this is the language that we would need in the financial power of attorney in order to be able for her to accomplish that. The next thing is the beneficiary designation language. So if we go back here a couple of slides, again, you're going to see here that under these powers, number 8 and number 9, your agent can engage in insurance transactions and can engage in retirement plan transactions, but it doesn't specifically authorize the updating of beneficiary designations. So that means that they would not be permitted to do that. And I actually have had a situation where I was planning for husband and wife. Husband was going into a facility. They were in their late 80s, and wife was still at home. She didn't need that level of care. And we wanted to update the beneficiary designations. Wife wanted to update them because if something happened and she passed away, she didn't want it all to go to her husband because it would jeopardize any benefits he'd currently be receiving for Medicaid and for nursing home long-term care costs. So we wanted to update that so that it would bypass the husband and go right to the kids. But the issue was that we couldn't do it under the power of attorney because there wasn't specific language authorizing that. The company wouldn't allow that. And another situation we had where husband and wife were both still in assisted living level, but wife had been diagnosed with dementia or Alzheimer's and her mental health was deteriorating rapidly. And husband wanted to create a special needs trust and update the beneficiary designations to be that special needs trust. But when I met with the client and I reviewed the document, his power of attorney and her power of attorney did not allow them to be able to update beneficiary designations. So even if he had wanted to change it from spouse to a special needs trust for his wife, so it's still going to his wife, but it would protect it against long-term care costs, he wouldn't have been able to do that under the power of attorney, meaning if he had ever lost capacity, nobody could update that if he hadn't gotten around to doing it. So our office recommends this language, and it's just allowing the designation and changing of beneficiaries on such plans and arrangements. And we specifically put this in there for life insurance, for retirements, for annuities, for transfer on death, and pay on death designations. So any possible designation on an account, we allow the agent to be able to update that beneficiary designation. Now, please know that this does allow your agent to update beneficiary designations to include them. So, for example, in my family, if I were listed as my parents' power of attorney, I would be permitted to update the beneficiary designation so that I could be a beneficiary. But Pennsylvania does have court cases where this has been litigated. And the important thing to remember is that I can update it to I can update the beneficiary designations, but it has to match what my parents' overall estate plan was, meaning that I cannot change their estate plan and have everything come to me. So sometimes I meet with clients who are afraid to add this language in there saying, well, what if my agent changes everything so that they're receiving everything under the beneficiary designation? And I just remind them that under Pennsylvania law, they have to comply with what the overall estate plan is. So again, we want to make sure that our language does not look like number 8 and 9, but rather looks more like this. This specifically allows the agent to update beneficiary designations. Okay, one of the other hot powers that we have is digital asset language, and this actually has changed in the last month. So we've had digital asset language in our power of attorneys for a couple of years now, but recently in the last month, Pennsylvania has specifically required language in there in order for somebody to be able to handle digital assets. Why is this important? This is important because a lot of times, especially as we're dealing with parents that are aging, there are children listed as the agent under the power of attorney. And if you want them to be able to do online banking or to be able to handle your online assets, maybe they don't live here closely, or maybe you do online banking yourself. If you want your kids to be able to do that, or your agents under the power of attorney to be able to do that, you specifically have to grant them access. Otherwise, legally, any action they take online would not actually be in valid action as the agent. So again, we specifically have to add digital language asset language in there in the power of attorney. Now, again, if we look back at the example, nowhere in here does it allow the agent to access digital assets. So if under this document, the agent did something online to any accounts, technically that would not be a valid transaction if they're using the power of attorney to do it. So again, we recommend digital language asset. Now, I just want to stop here and say, because a lot of times people have the question of, well, why can't I just add my children's names to the account? or add my agent's name to the account. Wouldn't that just be so much easier? Well, the answer is that it may be easier, but it might not be the best for you. And the reason is because when you add somebody's name as an owner on the account, there are two things that happen. The first is that it makes that asset available to that new owner's creditors. So, for example, if my parents would add my name to a bank account, and let's say I would get divorced, then those bank accounts that are actually my parents are then subject to my divorce because that's a creditor I have. And as a joint owner, they can attach to those assets. The second reason that we don't recommend that is because if my parents pass away, then technically it goes to me as the joint owner. It doesn't go through the will. So if I have three sisters, I'm one of four girls. So if I'm listed on the account, technically when they pass away, it goes to me. Now, even though in most families, the child who is the joint owner would happily share those assets, they aren't required to. So again, you don't want to create a situation where there's conflict in the family because it goes to the joint owner. So you don't want to just add a child on. The third reason is that if my parents added me and I predeceased them, my parents are going to pay inheritance tax on their own assets. So they would pay 4.5% on the value of the asset on my half share, for example, because I predeceased them. So again, those are three really big reasons why you don't just want to add your children onto an asset as a joint owner, whether that be real estate or whether that be a bank account. So again, we don't want to do it because it makes it available to our agents, creditors. We don't want to do it because legally then they receive that asset when they die, and we might actually want it to be divided among the beneficiaries under our will. And the third reason is because if they predecease you, then technically you're going to pay tax on your own funds. And so that's why we recommend using a power of attorney. Now, one of the questions I get is how do you sign when you're an agent under the power of attorney? And legally, how you should actually be signing is, let's just take my parents, for example. What I would do is I would sign, if my dad had appointed me, I would sign my dad's name and put by and through, and then sign my name as power of attorney. Sometimes banks will allow you to just sign your name and put POA after, power of attorney after, but the technical way would be to actually sign my dad's name and then put by and through and then sign my name and put agent after it. Another question I often get is, do I have to provide a copy of the document to banking institutions? And the answer to that is yes. If you want your children to be able to be accessing that account, then the bank does have to have a copy of the power of attorney. Now, what you can do is you can wait, and if and when your kids would ever need to use it or your agent would ever need to use it, they can provide a copy of that power of attorney at that time. One thing to know is that if you update your power of attorney and you've already given it to a banking institution, you do want to follow up and send them the new updated copy or the new updated financial power of attorney so that they do have the most recent one. Okay, so one thing I did want to talk about, we talked about the difference between springing and durable. I've given some examples of some language that you want to make sure is in your document. And then one of the last things I wanted to go over was a change that happened in the law. So in July of 2014, there was a law change. And the reason why was because there was a court case, and I have it referenced there. It was where a third party was liable for relying upon a valid power of attorney. Because what happened, and let me explain the situation. This was a situation with husband and wife had appointed husband in a power of attorney and then had lost capacity. She was in an accident and was incapacitated. So husband, using that financial power of attorney, went and made some elections using that power of attorney on some retirement accounts. And then what happened is when wife came out of her state of incapacity, out of her coma, they decided they didn't like each other anymore. And then wife was upset that husband had used the power of attorney to make certain elections. So banks weren't willing or as willing to accept power of attorneys. And that was problematic from a legal perspective, because a lot of times we need the power of attorney to be able to take action. There's a reason that you appointed that individual. It's because maybe you don't have capacity and you wanted to be able to say, this is who I want to have this power. So what happened was, effective in 2015, is if you sign it in the presence of a notary with two witnesses, then the presumption is that's a valid power of attorney. And the way that they determine that is a couple of different things. So a new notice came out in 2015. So if you're looking at your power of attorney, this is the new notice after that law change that has to be on the cover of your power of attorney. Now, that doesn't mean that any previously executed power of attorneys are no longer effective. They still are. It's just that now when a bank sees this new notice, see that it's signed in the presence of a notary and two witnesses, then the presumption is that this is a valid power of attorney and that they can rely on it to take action. So what I've seen is that it can somewhat be a hassle for agents if you haven't updated your power of attorney since 2015. Again, it's still effective. It's just that it takes a little bit more for banks. You have to kind of explain it. It's a little bit more back and forth sometimes before they're willing to accept the power of attorney. Because again, when the law came in 2015, the presumption is it had to have this notice, had to be signed in front of the presence of a notary and two witnesses, and then it would be considered, the presumption would be it's a valid power of attorney. So I encourage people that if you're looking through your power of attorney and it was executed prior to 2015, that you should probably update it. Now, again, you may want to be updating it if you had executed it prior to 2015 for a whole bunch of other reasons dealing with those hot powers that I talked about, because there's been changes about using specific language. And so even if you had executed, let's say in 2000, there may not have been the requirement that you needed that special language at that time. But now we know you need this special language in order to make gifts, in order to create an irrevocable trust, in order to update beneficiary designations, and in order to be able to handle digital assets. So again, you may want to make an appointment. And again, we offer free initial consultations, and bring the document in. Just have your legal professional review it to make sure that it's in compliance with the 2015 laws and that you have all of the powers in there that you would want. Okay. Now, one thing I did want to go over is just what other powers should be in there. And I will tell you that I see a lot of power of attorneys that are, 10 pages or less. I've even seen some that are 2 pages. And I know that whenever you're dealing with a power of attorney, that it can seem overwhelming. But I will tell you that the power of attorney that our office drafts for its clients is about 25 pages. And that's just because you need all of that specific language in there now with all of the law changes in order to make sure that your agent does have all the power that you want them to have. So again, I would encourage that you look at your document, see what it has in there, and then make an appointment to have your document reviewed. Okay, I just wanted to make sure everybody knows that, again, we were talking about the financial power of attorney, and that I would encourage anyone to look over it, make an appointment. You can call our office at 717-655-2676, and we do free initial consultations. And what we recommend is that you bring any documents you want me to look over during the appointment, and I would be happy to do that and make any recommendations. Okay, so I know that that was a lot of information, but I hope that it was helpful for me to actually go through the different provisions and review it with you. If anybody has any questions, you can always drop a comment in the comment section, and I'd be happy to either reply. I can type up a response, or I can always do a video response as well if we have some interest in that topic. So I hope this was helpful. And again, this was reviewing the financial power of attorney.